So here to talk about this, the fight for America's rifle, the state of assault weapon litigation, is William Bergstrom, litigation counsel for legendary law firm for the SAF, Cooper & Kirk. William, welcome. Thank you. Clock's right there.
All right. Good afternoon, everyone. Thank you to Second Amendment Foundation for having me here to talk to you about this important topic. I am Will Bergstrom. I'm an attorney at Cooper & Kirk. I've had the privilege of representing SAF on a lot of Second Amendment cases all over the country, several of which dealt with the AR-15 and several of which I'm going to talk to you about today. And we're going to get to the AR-15, but before we do, I want to start by talking about Heller, because I think that Heller is the critical case to understand assault weapon bans and bans on any type of arm, because that's what Heller was about. It was about a ban on a type of arm. And so if we're dealing with a similar case today, that's where we should start. Bruin, Rahimi, McDonald, they all come into play, but Heller is the foundational text. And I'm going to talk to you today about the key passage in Heller for understanding these cases. And before I do, I want to set the stage for this passage. So at this point in the opinion, we're near the end of Heller, and the Supreme Court has already done the textual work. Arms is anything a man carries for offense or wears for defense. All firearms are arms in the text of the Second Amendment. It's also done the historical work, and it's found two historical principles or traditions that are relevant to understanding what types of arms are protected by the Second Amendment. And it said, first, there's a tradition going back to the 14th century in England of banning dangerous and unusual arms, or banning the carriage of dangerous and unusual arms. And at the same time, there was a tradition at the founding of people showing up for militia duty with the same firearms they kept in their house for everyday purposes. So we have these two traditions. One, dangerous and unusual arms that can be banned, and arms that are in common use for lawful purposes that are per se protected. It's not difficult to see how those fit together, but if you're the Supreme Court in 2008 writing Heller, there's a little bit of a conundrum in this. And that is that the Second Amendment begins with what's called the prefatory clause, the part that says, a well-regulated militia being necessary to the security of a free state. And then it finishes with the operative clause, the right of the people to keep and bear arms shall not be infringed. And Heller tells us the prefatory clause explains why the founders thought this right was so important it needed to be in the Bill of Rights. But if you are going to do militia-like activity today, in 2008 when Heller was decided, it's a good chance that you're going to be using a firearm that is not like the common firearms most people have in their house. The military today does not run on the same type of firearms that people own at home. And so this is the problem that's being set up in Heller. And this passage I'm going to read you is Heller anticipating this objection and working through it. Heller says, it may be objected that if weapons that are most useful in military service, M16 rifles and the like, may be banned, then the Second Amendment right is completely detached from the prefatory clause. But as we have said, the conception of the militia at the time of the Second Amendment's ratification was that the body of all citizens capable of military service who would bring the sorts of lawful weapons that they possessed at home to militia duty. It may well be true that no amount of small arms could be useful against modern-day bombers and tanks, but the fact that the modern developments have limited the degree of fit between the prefatory clause and the protected right cannot change our interpretation of the right. Now, I said at the beginning, I think this is the critical passage for understanding bans on AR-15s and other common arms. I also think it's the critical passage that's being misunderstood by courts that are upholding these bans. And I'm going to start with how it's misunderstood. The Fourth Circuit, in the Bianchi case, which we litigated, which you may be familiar with, upheld Maryland's ban on AR-15s. The Seventh Circuit, in the Beavis versus City of Naperville case, upheld the Illinois assault weapon ban and large capacity magazine ban. Again, put air quotes around all those words every time I use them, if I forget to. And in both of them, they relied on this passage I just read you to find these laws constitutional. And I'll read you the Fourth Circuit in Beavis says this. The court there is the Heller court, recognized that weapons that are most useful in military service, such as the M16 rifle and the like, can be banned. The Heller court placed such weapons of crime and war in explicit contradistinction to the handgun, the quintessential self-defense weapon, which it emphasized was squarely within the ambit of the Second Amendment. Now, I just read you that passage. It doesn't say anything like that. It does not say anywhere that M16 rifles can be banned because they're used in the military. Heller was saying exactly the opposite. It was trying to explain why some firearms can be banned even though they're useful in the military. In other words, utility in the military is never the because for why a firearm is banned, it's the despite. Some firearms that are useful in the military can be banned despite utility. But so that's the first error that these courts are making with this passage, but that's sort of surface level. That's just misreading and misconstruing that passage. There's a deeper error here too, and that is that the reason the Fourth Circuit and the reason the Seventh Circuit found this to be an acceptable resolution of the case is they viewed the Second Amendment through a narrow lens of what they thought its purpose was. So they both said that the purpose is individual self-defense. Now, I've got no dispute that that is a purpose the Second Amendment protects, but it is certainly not the only one, and Heller never said it was the only one. Both the Fourth and the Seventh Circuit treat it as the sole purpose, and everything they do follows from looking at it through this lens. I'll read you another part of the Bianchi decision. The Fourth Circuit said, the AR-15 offers firepower ill-suited and disproportionate to fulfilling the Second Amendment's purpose of armed self-defense. Therefore, just like the M16, the AR-15 is most useful in military service and can be banned. So that's the crux of their reasoning. It's overkill for self-defense. You don't need it for self-defense. It can be banned. But that passage in Heller said exactly the opposite. That passage in Heller said purpose is not driving our analysis. There is instead a thing that is the Second Amendment right. Now, it was included in the Constitution for any number of purposes, but it is itself a thing that we can know. We can know it from the text, we can know it by looking to history and finding purposes, or not, using the wrong word, finding principles that underlie it. But it is not the purpose that drives the interpretation, it is the principle. And that's really why I think Heller is so critical to understanding everything that's come since it, and this passage in Heller specifically. Because as we've probably heard today, the Rahimi decision, of course, makes clear that what you're looking for when you're doing a historical analysis is the principles underlying the Second Amendment. And if I can do a little digression away from AR-15s for a second, I think that the understanding this principle distinction is really critical as advocates for the Second Amendment, because we are charged all the time with the idea that the Bruen decision is completely insane. The New York Times had an article last week you may have seen that collected just sort of complaints from judges, complaints from lawyers, complaints from academics, all saying it's crazy that we have to do this. The Supreme Court's tasking these people with this task. They're not up to it. They're not historians. They don't know how to do this. And the principal distinction that Rahimi makes shows why those complaints are baseless. It is not a job for historians. It's a commonplace task for lawyers to find a principle from historic cases, from historic laws, and apply that principle to a law in front of them today. It's what you do in every other legal case. The way this plays out, for example, again, digressing a little from the AR-15 example, you may have seen the Ninth Circuit decided a case a couple weeks ago, Wolford versus Lopez. This is a sensitive places case, a case about where firearms can be banned. And they were reviewing a California law and a Hawaii law that banned firearms all over the place. And at the end of the opinion, the majority, or the three-judge panel of the Ninth Circuit had found some of the restrictions constitutional, others not constitutional, and it sort of threw up its hands at the end of the opinion and said, look, you might say there's no rhyme or reason to the fact that you can prevent guns from being carried in parks, you can't prevent them from being carried in parking lots. And they said, we agree, there's no rhyme or reason to it. All we're doing is this mechanical, applying Bruen, looking at history, and on some of these issues, California and Hawaii showed us enough laws that are kind of similar to laws banning firearms in parks, and they didn't show us enough laws that are kind of similar to laws banning firearms in parking lots, so that's how the cookie crumbles. But that really reveals not that the Bruen analysis is broken, that there's something wrong with this historical test, but that they didn't do it right. That the underlying problem here is you need to find a principle. You need to find a principle and then apply it across all of those cases. There should be a logical dividing line between places where firearms can be banned and firearms where they can't be. In the case of the AR-15 now, going back finally to what you all want to hear about, we see the same exact thing. A lot of the analysis, both by litigants on the other side and by courts, is, look, the AR-15 is very like the M16. It looks the same. It shoots the same ammunition most of the time. It's got the same muzzle velocity, same effective range, same maximum range. And they say, look, it's all the same. And so if you're doing the same sort of mechanical, is something enough like another thing that I can ban it, that I can analogize laws to it, it's easy to fall into the trap of saying, well, look, the AR-15, yeah, the M16 has select fire, but look, all these other things are the same, and they're pretty much the same. The problem is that the principle underlying the ban, underlying arms bans that Heller has already given us is common use. And if you compare the AR-15 and the M16 along that metric, they're not the same at all. There are tens of millions of AR-15s in the country today in civilian hands. That is not true of select fire rifles. That's not true of machine guns. And so if you look at it through the lens of the principle, this is the advantage of both being right under Rahimi, being right under Bruen, and finding that most of the laws, most of the firearms that we argue about are constitutionally protected in a very straightforward way. You find that the common use principle gives us sort of the guiding light to holding these laws, to finding these laws unconstitutional. And on this topic, before I move on, if you're interested in this issue, if this is an issue you're either litigate or you're an advocate on, I would recommend, Mark Smith was just in here talking, I think he's still out there signing books. He has a good article through the Harvard Journal of Law and Public Policy that we cite a lot of the time that sort of explains the way this common use test can be found in the passage in Heller that I'm talking about and is consistent with Bruen. That's another charge that comes up a lot. Is that, well, look, Bruen tells us to do historical analysis. Don't you have to do a new historical analysis? Let us show a bunch of firearm laws and see whether or not they're like the laws banning the AR-15 today. And the answer is no, we don't. Because the Supreme Court has already done that work. In any other context, if the Supreme Court has decided a case that gives you a principle that decides your case, you wouldn't say we need to check the Supreme Court's homework. You wouldn't tell the Seventh Circuit, no, you need to do your own in-depth analysis. You'd say, no, just apply the test the Supreme Court has given us. And the good news in the context of the AR-15 and in most of the other, all of the other firearms banned in these sort of omnibus firearm bans that places like Illinois and California and Maryland pass, is that common use is a remarkably easy test for us to meet. There is no argument that, well, there is an argument, there's just no good other side to the argument. They argue it anyway. But there is no good argument that the AR-15 is not in common use. We have survey data. The Washington Post's own survey data says tens of millions of these things are in the country. We have manufacturer data. We have import data. All of it points in one direction. And if courts take the common use test seriously, if they get this passage in Heller correct, these cases are remarkably simple to resolve. In the Bianchi decision that I've mentioned several times today was 183 pages all told. And that's the majority, that's 2 concurrences and a dissent. But 183 pages all to sort of sort out whether or not an AR-15 is an arm and is protected by the Second Amendment. Judge Richardson, who wrote an excellent dissent in that case, had, I think, 2 sentences in there that I'll leave you with as, I think, the proper outline for how to think about this. And had he been writing for himself, he may have been able to resolve the entire case in these 2 sentences. Judge Richardson said this: plaintiffs seek to own weapons that are indisputably arms within the plain text of the Second Amendment. That's the text analysis done. While history and tradition support the banning of weapons that are both dangerous and unusual, Maryland's ban cannot pass constitutional muster as it prohibits the possession of arms commonly possessed by law-abiding citizens for lawful purposes. That's the whole story. That's game over in these cases. It has the advantage of being consistent with the passage from Heller I read you. It faithfully sticks to the Bruin's methodology and applies it correctly. It does what Rahimi asks it to do in finding an underlying principle and applying it to the facts of the case at hand. And it has the singular advantage of being a correct interpretation of the Second Amendment. So if you are a supporter or an advocate who finds yourself talking to the media or arguing to courts about these issues, I'd point to Richardson's 2-sentence dissent as the model for these arguments for us. Thank you very much for the time. It was a pleasure talking with you today.